Hi, my name is Stephanie Tang and I'm a family law attorney at Kogut Wilson. Today I'll be discussing 5 things that every family law attorney should know about the amended child support statute that was enacted on July 1st, 2017. So the first thing that all family law attorneys should know about the amended child support statute is that it uses 2 tables that were developed by the Illinois Department for Health Care and Family Services. The first table is a gross to net income table, and the second table is a schedule for basic child support obligations. The first gross to net income table uses a standardized tax approach, which is now the default approach under the amended statute, to calculate a party's net income for purposes of calculating child support. The schedule for basic child support obligation uses economic data gathered by the Illinois Department of Health Care and Family Services in order to analyze the amount spent by families depending on their combined family incomes and size of the family. The second thing that all family law attorneys should know about the amended child support statute is that it now expressly takes into consideration how many overnights on average a parent has in a given year. Specifically, the amended statute provides that if a payor does have 146 or more overnights on average a year, then additional steps need to be taken in order to calculate their child support obligation. The third thing that all family law attorneys should know about the amended child support statute is that it now codifies the concept of imputation of income, which was previously analyzed in the seminal cases of In re the Marriage of Gosney and In re the Marriage of Sweet. Specifically, the statute now provides that if a court finds that a party is voluntarily unemployed or underemployed, then the court should then consider the party's potential income based on their probable earning level, based on their previous work history, occupational qualifications, or the prevailing job opportunities in their field. This opens the door for vocational experts to come in and testify in future child support hearings. The fourth thing that all family law attorneys should know about the amended child support statute is that it now takes into consideration children's expenses in its calculation of child support. Specifically, the statute now gives courts discretion to consider payment and contribution to children's expenses such as specific child care expenses, extracurricular expenses, and health care expenses in calculating child support. The hope for this is to reduce future post-decree litigation for parties who don't want to seek reimbursement from each other after a final divorce judgment is entered. Finally, all family law attorneys should know that the amended child support statute now provides a minimum child support obligation as a rebuttable presumption. Specifically, the amended child support statute provides a rebuttable presumption that a $40 per month per child support obligation should be entered for a party who's found to have an actual or imputed gross income at or less than 75% of the HHS federal poverty guidelines for a family of 1 person. However, it should be noted that this $40 a month presumption is not applicable for cases where a party is found to have 0 gross income, is found to have a medical condition that makes them unable to work, or has only means-tested assistance. I hope you learned some valuable tips about the amended child support statute today. To learn more about the benefits of joining our ISBA Family Law section, check out the ISBA website listed below.